Bismillah ar-Rahman ar-Rahim. Ladies and gentlemen, today we will discuss a little bit about law. There are three main types of law. One is the state law, criminal justice system. One is the religious law, and the one is the traditional or indigenous system, which we have already in different parts of the world. Maybe in the West it is not that much common, but in the rest of the world, still the indigenous or the traditional law is practiced. Definition of law is, if you say, similar feeling grouped together and summarized into a simple generalization called laws. Then second definition is rules of conduct and procedure established by custom agreements and authority. Again, it is law. Third definition is rules established by the governing authority to institute and maintain orderly coexistence. That is also law. But if we look to the why law are made, so this is to keep and maintain peace and security in the society. Second, the law is to reform the offender. Third is to control the offender. Fourth is deter offender from further crime. Fifth one is deter other from committing a crime. And the final one is restore empathy symbolically and substantially. These are mostly the law is made to do these things. So there are different, as I mentioned before, there are different Islamic law. We have, suppose in our culture, in other tradition, they have their own law. Like in traditional law, they have and civil and criminal law. You see, that is also the government made law. In our Islamic law, suppose there are in the Holy Quran, there are 6,666 different ayah, we call it, and only 30 are for the punishment and crime. The rest are for the community to make it how to suppose resolve our conflict or problem. So, what is the communal way? What is the Islamic way? That is mostly in the Holy Quran to how restore peace in our community. So only 30 are on the punishment side and the crime. Traditional law, suppose we have different in our part, suppose in Pakistan, Afghanistan, we have Jarga, India and Pakistan, we have Panchayat, and then we have another Sindh province, Faisalo, that is called, and then in Balochistan, that is Kachari and Mad. Similarly, it is in the Middle East, support is Solha, in Africa, in some parts it's Gachacha, but many other names are there. In Philippines, suppose there is Badung, and so in Bangladesh there is a Chakma and Panchayat. So every country have their own system. They preserve it since time immemorial, which is coming from generation to generation. All is verbal. Uh, it is mostly transfer from the elders to the youngster, and it go on. This now it's the time that we should document it because there are many good decisions those indigenous system they have done, but the young generation it is they don't know much about it. So suppose in Pakistan, which we established this uh, police station dispute resolution council or Masaliyati committees, there we have now place a system that every and each and every uh, the complaint which is reported to them, it is registered there, and this decision is also, and sometime even the court also, they want that what sort of decision has been taken, and those register has been taken to the courts, and in majority cases, the courts also agree what the elder have done. So this is a very important aspect that we should uh, the document those those which is uh, in our the system is. So one of the Islamic system which I already discussed there are these hudud, qisas and diyat and tazir. Qisas is the, as I mentioned before, the judge will just after the witnesses he will decide that a person has killed someone. So yes, he should be killed. That is qisas. But again, I will mention that three times before that qisas, the judge asked the parties, the victim parties, that if you forgive him or if you want to money, blood money, that is called, so that is also available to you. If the third time they say no, we want to take qisas, to kill the person, to take revenge, then they go for it. And second is the different hudud, which is there, uh, like suppose the honor crime. There are different in Islam, different crime. Then tazir, that is another aspect of the rest is this I already court and type of cases which is in the criminal justice system that is there. Then there are different laws, like suppose punishment theories which were retributive. Shedding of blood is reduction of sin. This is retributive theories. Focus on pain, suffering, death as criminal payment for offenses. Unjust to victim and offender if offender not punished. This is retributive. Utilitarian deterrences, this is another theory. Punishment should protect community from offender. Second is focus on utilizing offender as instrument of deterrence for others. So these are utilitarian theory, which is there are five theories which I'll discuss. These two are here. Then the other one is uh, the rehabilitation theory. So offender is a patient, victim, or possibly both. General public typically resists this theory. Uh, these are we have a long discussion with Howard Zia on this that, especially in the restorative justice system, that offender have also many problems before committing a crime, and that is not addressed, and it should be addressed by the community before that. In our culture, suppose offender mostly go to the elder and he discuss before committing any crime. And he asked the elders to come in the middle and just resolve my issue. If not there, so then in at home also, to the religious leader also. But if we did not get that, so then he go for his crime. Another theory is institution. Institution place victim need at forefront. And second is does not achieve restoration of a relationship between victim, offender, and community. This is restitution theory. And the final one is the our main, which we will discuss. Uh, no, this is restorative theory. Here in the restorative justice system focuses on the partition, offender encouraged to understand harm caused and take responsibility. Dialogues is encouraged. Community play an important role. Assume that justice can be and should promote healing and individual of individuals and society, and relatively recent to view victim as without standing, focusing on guilt and punishment. So restorative justice is mostly on the responsibility taken by the offender, the victim, the whatever the healing and the compensation of what losses he has done, and community to sit together because each crime make fears in the community also. So community also is affected indirectly from any crime. So if the crime is resolved in the proper way, so both community, victim, and offender, first of all, that is rehabilitated, and second is that punishment or what is not punishment, but what the rehabilitation process again create a sort of uh, harmony in the community. This is just for today, the different law and what are these. Inshallah, later on we will discuss and further topics. All the best. Assalamu alaikum.